Misesny versus Sesny. Attorneys, may I get your appearances?
Caitlin Zone on behalf of the plaintiff, the state of Judith Ann Sesney.
Ben Falick on behalf of the defendant, Lisa Sesney.
And Miss Sesny, would you please state your name for the record?
Lisa Ann Sesney.
All right. Good morning to all the parties. We're here today for a motion to stay. Mr. Falick, go ahead.
Yes, Your Honor, following our motion for reconsideration, we are asking the court to stay the writ of eviction pending the defendant's appeal to the circuit court.
For what reasons? And I have read your motion, but I would like for you to place them on the record.
Yeah. Oh, so I don't, nothing to add in addition to what is in the motion, but the appeal will be as to whether the defendant was afforded her procedural rights at the Vice of Rights pretrial in December.
All right. And you have not filed an appeal yet, is that correct?
That is correct.
So it's just the motion for reconsideration and the motion to stay. And Mr. Falick, no transcripts have been ordered yet. Am I correct about that?
I would have to check with my office, but not that I'm aware of.
Okay. All right, Ms. Zollner, would you like to respond?
Yes, I oppose the motion. As stated, an appeal has not been filed. Also, I would just like to note we did file a motion for escrow yesterday. I'm not sure.
I received that.
Okay.
I received.
And then if an appeal should move forward, we'll be seeking a bond on appeal as well.
All right, so should there be an appeal filed, obviously we'll have to address the bond issue at that time. Right now, it's just we'll start with the motion for reconsideration on the basis of the process that was afforded to Ms. Sesney in this case. Mr. Falick, just by way of making a record, you work for Lakeshore Legal Aid. You agreed to, you screened Ms. Sesney. You took her on as a client, filed an appearance, and now we're here today. At our previous hearing, the court found judgment for possession for the plaintiff in this case based on a mediation settlement that Ms. Sesney entered into after she had a retained attorney, and this matter was settled through a matter in probate. There's a mediation settlement in this case whereby she agreed to vacate by November. Ms. Sesney stated on the record that she did engage in this mediation settlement, that she signed the agreement. She also stated on the record that she did not think she would actually have to leave, and that she thought that it would be more like February when she'd have to leave. And it became very apparent to this court throughout those proceedings, looking at the totality of the circumstances in this case, that Ms. Sesney had negotiated with her retained attorney in bad faith with the plaintiff in this case. This court allowed Lakeshore Legal Aid, Mr. Falick, allowed you to go into a breakout room where you spent over 35 minutes with the defendant in this case, interviewing her, screening her. And when you came back into the Zoom courtroom, this court tried to determine whether or not there was any triable issue in this case. And over the course of that hearing, this court determined that there was no triable issue in this case, and judgment was issued in favor of the plaintiff. Mr. Falick, as far as process in this case, again, this court afforded Lakeshore Legal Aid time with Ms. Sesney, over a half an hour in this case, which I will say for the record is not something that typically happens. Typically, Lakeshore Legal Aid is afforded 5 to 10 minutes with each defendant in this case. And we appreciate that Lakeshore Legal Aid is here. We at the 45th District Court firmly believe that it is important for indigent defendants to have access to counsel, even though there is no right to counsel in these cases. So we really appreciate that Lakeshore Legal Aid is here to provide counsel for our indigent defendants. This defendant received over a half an hour with you, Mr. Falick. I believe there was also some back and forth with the plaintiff's attorney. And I will also state, just by way of process, Mr. Falick, again, we are so grateful to have Lakeshore Legal Aid here. We do believe that indigent defendants should have some access to counsel, even though they don't have a right to it. We believe here at the 45th District Court that it is the right thing to do. I will say that, Lakeshore Legal Aid does not take everyone on. You do a screening process, and you evaluate whether or not they financially qualify for your services. And it is not the court's place to engage in any of any screening. That's up to Lakeshore Legal Aid to do. Over the course of this hearing, though, it was placed on the record that Ms. Cesny does live in a home in Huntington Woods that is valued at close to $1 million, that a trust has been set up for her through that probate proceeding that we discussed on the record, and also that she previously had an attorney of her own that she hired during the probate proceedings. So, Mr. Falek, I'm sure during the screening process, I don't know if Ms. Cesny represented any of that to you. That is between you and Ms. Cesny, and if there is any issue there, I'm sure Lakeshore Legal Aid will have to determine whether or not there's any recourse against Ms. Cesny. So again, this court allowed an inordinate amount of time for Lakeshore Legal Aid to interview Ms. Cesny. There was no tribal issue. Through the process of the hearing that was held here, it was abundantly clear to this court that Ms. Cesny negotiated in bad faith when she entered into that mediation settlement, and she had no intention of honoring that agreement, and there was, quite frankly, no tribal issue in this case. So the motion for reconsideration is denied. For the motion to stay, Mr. Falek, you have to demonstrate to the court that you're likely to succeed on appeal, which cannot be done here. Also, it looks like there's an abusive process here. There's no manifest injustice to the defendant. If anything, the defendant has taken advantage of process in this case. So the motion to stay is denied. Let's talk about the motion for escrow.
Yes, Your Honor. So we filed a motion.
Your Honor, if I may, briefly.
Go ahead, Mr.
Falek. As you said, the conversations that Lakeshore Legal Aid has in the Zoom breakout rooms, and again, we appreciate being afforded the opportunity to be present on the docket, are confidential and consist primarily in that half an hour of doing an extensive intake, not on the substance of the case, but initially to determine whether gather information, just demographic information, and to make sure that we, within our sometimes draconian funding parameters, can even advise, let alone represent the client. At the December pretrial, the defendant and I had approximately 5 minutes to speak. Not the legal assistant who did the initial intake. The defendant and I had, I would say, approximately 5 minutes to speak prior to being recalled back into the main court session. I didn't have an opportunity to speak in a breakout room with opposing counsel. Not that I'm necessarily entitled to that, but that is common under these circumstances. And I had no opportunity to review any of the documents to even advise, let alone represent the defendant. I hadn't yet filed my appearance. I did indicate that I would, and I subsequently did file my appearance. The triable issue that we have since determined is whether the estate or members, and Ms. Cesny is an interested party in the estate, whether the other members in the estate interfered with Ms. Cesny's possessory interest in the property between the signing of the agreement and November in such a way that has made it more difficult for her to vacate, which is still her goal and her expectation. And again, whether that would be a winning, I'm sorry, whether that would be a winning issue, determining at the advice of rights hearing that there is no triable issue is an infringement on her due process, which is why we're seeking to take this matter to the circuit court, where I'm aware of no other court that issues judgments at the advice of rights. And that's why we want the circuit court to determine whether she was afforded her full due process.
Mr. Falek, you're still not putting any actual tribal issue on the record. You're making a blanket statement that there was some sort of interference with her possessory interest.
That's the triable issue.
I was not sure.
What happened, Ms. Cesny?
Your Honor, may I?
Hold on. Let me let Mr. Falek.
I'm sorry. I thought it was muted. I thought it was muted. I'm sorry. I was just saying I was never served this. I was never.
Ms. Cesny, I need to speak with your attorney. All right, Mr. Falek. When you say, I just want you to put on the record how what are the allegations that her possessory interest was interfered with? Because that was not placed in the motion.
Again, this is information I have been attempting to gather subsequent to the pretrial, but that first that it was not a bad faith negotiation, but that the Miss Cesny relied on assurances from both parties that a November vacate date would afford her, or November in the agreement would afford her staying until February if she needed that amount of time, and then subsequent to
the agreement.
Miss Olna, hold on.
Go ahead, again, we're not here to litigate that. I don't have witnesses or exhibits. What I was asking for, and that's why this is a procedural appeal, was an opportunity to have an evidentiary hearing so that the court could determine, after hearing under sworn testimony, which you did not have, they were not under oath at the pretrial, to determine whether there is, not whether there's a trial, to have a trial that she's entitled to.
Mr. Falick, you're still stating these blanket accusations that her possessory interest has been interfered. You've now had a very long time to speak with Ms. Cesny, so she has had you as her attorney for quite some time, and there's still nothing that you are articulating on this record that presents a triable issue other than a blanket statement. So I would just, Mr. Falick, it's not there. Mr. Zolna, Ms. Zolna, go ahead and respond.
Thank you, Your Honor. I just wanted to indicate that once the motion for reconsideration was filed, there was no additional proofs or evidence to support any of these claims, and none of these claims were even presented in the motion for reconsideration. I would presume after Mr. Falick had enough time to speak with the client that a motion for reconsideration would include some sort of additional proofs. There's nothing, because there is nothing, right? We have the settlement agreement. It says what it says. There's no caveat.
Which was acknowledged on the record by Ms. Cesny.
Exactly. There's no other carve out in it, or else that would have been present in the settlement agreement itself, and it is not.
All right. The motion for reconsideration is denied. The motion for stay is denied. Let's move on to the escrow order. Ms. Zolna, that's your motion. Go ahead.
I'm sorry, you cut out, Your Honor, on my end. Did you say motion for escrow?
Yes. Let's move on to the escrow order.
Okay, thank you. My apologies. So we filed this motion for escrow upon defendant filing this motion for stay. What it comes down to is the fact that this court granted judgment in favor of plaintiff regarding plaintiff's demand for property on December 23rd, 2024. Defendant filed a motion for reconsideration on January 1st. It was denied January 2nd. Defendant was required to vacate the premises by January 3rd, but she did not. This court entered an order of eviction on January 3rd. Defendant has yet to vacate the premises and has essentially put on the record that she has no intent to do so. So thus, we are requesting that defendant escrow rent from December 23rd, 2024 until further order by the court in the amount we proposed of $7,163.25 per month and prorated, as the property has been valued at approximately $859,590 for the 4-bedroom and 3.5 bath property. We calculated the monthly rental payments at 10% of the property value, which comes to $85,959, and then divided by 12 months to arrive at the $7,163.25 figure.
I'm pulling up your motion. What was the square footage of the house?
Jill, can you let us know?
Unfortunately, I don't know the exact square footage at this point. It is a 4-bedroom house, 3 baths, colonial. I don't have the accurate square footage. I'm sorry, Your Honor.
All right, give me a moment. That's something that can be readily obtained. Give me one moment. I'm gonna go off the record.
Your Honor, if I may, 3,412.
Thank you.
All right, we're recalling 2403881 LT. All right, I've reviewed the escrow order. So Ms. Solna, there are very few houses that are for rent in Huntington Woods. Very, 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 very few. This is an exceptionally large house for the city. It's on one of the largest lots in the city. Most likely, it will sell for more than what it's valued at. However, typically, we see houses around 1,800 square feet that are for rent in the city. And there's, again, it's just a handful of them. Rent is anywhere between 2,200 and 2,800. Given the square footage of this house, I believe the rental value would be somewhere around 3,500. However, I'm not going to enter an order for escrow. The writ is in effect. So Ms. Solna, just send in the order that the motion to stay and the motion for reconsideration is denied. The writ stands. It can be immediately effectuated. That just means you have to get the order in and contact the court officer.
Thank you, Your Honor.
All right, everyone have a good day.
You too.